themselves for the record, please. Ma'am, beginning with you.
Tracy Ann Peterson.
Morning, Your Honor. John Studley for Tracy Ann Peterson.
Good morning, Your Honor. Pamela Marshall for Kristian Pedersen.
You can have a seat for a moment. Attorney Studley, is your client asking to extend the order?
She is, Your Honor.
Everyone can have a seat, please.
Monday. My mother sent it to me Monday.
Attorney Studley, I'll hear from you.
Thank you, Your Honor. My understanding is we've agreed to proceed by representation. My sister and I have agreed on that, so I put that on the record. Your Honor, Ms. Peterson is a nurse at Brockton Hospital. She's a registered nurse. She's been a nurse for over 15 years. She's married to Mr. Peterson about 11 years ago, and they have 4 children, ages 12, 10, 6, and 3. Her marriage to Mr. Peterson has been rocky much of the time. He was a severe alcoholic and drug abuser for many years during the marriage. And about 4 years ago, he threatened, came home intoxicated at night, threatened to kill her and the children. He ended up going out into his car and passing out on the car, and the wife huddled in her room with the children sleeping in her bed at that time. About 7 years ago, she found an email correspondence between him and a woman in out of state, where in the email correspondence, he had threatened to tie steak to her legs and tie her in the woods in Maine so that she'd be eaten by bears, and there'd be no evidence of her whereabouts. She found that many years ago. So after the incident where he came home and threatened to kill her and the children, I guess that was where he hit rock bottom in his alcohol and substance abuse, and he stopped drinking. So he's been sober about 3.5 years, though my client has suspicions that he's recently begun to drink again. So during the last year, things began to deteriorate, and the Monday of September 1st, I believe is the date, they were going out, it was a Tuesday, they were going out to dinner, taking the kids on their annual dinner trip right before school starts. They were going to go to Red Robin. She came out of the bathroom, she saw her husband going through her phone. On her phone, there was a text message with a woman coworker where they were trying to arrange going out for a cocktail or two after work some night. So he became enraged. He accused her of having a sexual affair with the son's wrestling coach. He essentially, from that point on, went on a nonstop tirade, including in the car, in front of the children, accusing her of sex with the coach. Her son came up to her and said, "Dad is accusing you of having sex with the coach," and he confronted her. He was using the C word, the F word, the S word, all in front of the children. At some point in time, she finally said, "This has got to stop." At the restaurant, he did stop. He came home. Later that night, he again started at her, cornered her in the bedroom, and again kept the kids up, ranting and raving. And it wasn't an argument. It was a one-way rant by him, again, mindlessly accusing her of having an affair, something he's done over the years incessantly accusing her of these imaginary affairs. So this continued to go all week long at night, and the kids were to the point where they were sleeping with her. 3 of her children were sleeping with her at night. It ended up Thursday night she had to sleep with a cell phone under her pillow because he just was badgering her and screaming at her. And 2 times he cornered her in the dining room where she could not leave the room, and he had her cornered. So the weekend was a scheduled day for him to take the children down to the Cape. He has grandmother owns a home down there, so and she wanted him to leave because he just wouldn't leave this issue alone, this imaginary relationship. So he took the kids down, and she writes in her affidavit, it was a Sunday night that he came back. It was a Monday night. Monday was a holiday, so when she was so rattled, she was thinking that the next day was school, but it was really Monday night that these events occurred, so she made a mistake in her affidavit. He again came home and demanding, telling her that she's mentally ill. And about 3 weeks prior to this, he had specifically told her, for some reason, only to intimidate her, that he had now had an illegal handgun in the home that had been given to him by a coworker because he needed it because the coyotes were on the base. And one of her sons had said that the son had seen the handgun, and that he told the wife that he had kept the handgun hidden in the TV. So at this point in time, he's again telling her that she's mentally ill, that she needs take a pill, that she's not her low sex drive is causing her to be insane. This bizarre rant that was going on. He then engaged in what I would call a social media war, where he started texting and emailing and posting on Facebook derogatory comments about the wife. In fact, Your Honor, Judge Sabatis, on the restraining order that was issued, if you note on the very bottom of the first page, indicates that the husband shall not disparage the plaintiff to the children, which he's continued to do, by the way, and not post any comments regarding mother on social media. Well, this is a social media Facebook post that he posted Sunday after the issue of the order. He'd been served. And he says, the next 2 days are probably the most important of my life. I'm trying to see my kids, trying to get 50-50 custody. If you're in Brockton on Tuesday, if you happen to come sit with me, I appreciate your support. My kids know what's happening is just wrong. Please keep me in your prayers. So again, he's essentially accusing the wife of wrongdoing by getting a restraining order on social media in violation of the order. So I suggest he's violated that order. 2 occasions in the past, he's forced the wife to engage in sex against her will. This was in her mind, and these weren't just coercion. These were physical confrontations. She'd be prepared to testify that he held her down and videotaped one episode, and he essentially raped her against her will. And the next day, he was intoxicated during those events, and the next day when he viewed the video, he apologized profusely, deleted the video, or he told her he deleted.
How long ago was this allegedly?
That was 7 years ago in...
we can't be going back 7 years.
Right.
I mean, if something happened 7 years ago and nothing has happened since then,
Right.
I've got to hear something more current.
I understand that. And what I'm saying is he placed, because of the events that have happened in the past, the 2 death threats, the 2 episodes of him forcing her to engage in sex against her will, and this tirade that happened this week, this placed her in fear. She's been a wreck. She hasn't been sleeping. The children are a wreck because he's going off in front of them. They're not sleeping at night. She's not sleeping at night. She had to sleep with cell phones because of his bizarre behavior. And these have placed her in fear of imminent physical harm by the fact that he's told her that he's also had an illegal gun in the home. There's no other reason to tell her that, I suggest, other than to intimidate her and to force her to stay with him, and that's essentially what he's trying to do. So the combined, and this, I'd cite the case of NB versus JB, where it says, essentially, evidence was sufficient to support the issuance of an abuse reorder because former husband had a past history of anger and violence, and there was ongoing escalation in contact. The former wife provided affidavits stating the husband had anger management issues and there had been a past history of violence. She's testified that the husband had been physical with her prior to their separation. That's this case. He has been physical with her. He's threatened to kill her. He's got an illegal gun in the home, and he's gone wild over the last week. She had no other choice but to seek a restraining order to protect herself, and she is in fear of imminent physical harm if these two people were to live together. So that's why I'm asking you, based on all of that, and I'll cite that case as 86 Mass Appellate Court 108. This case is that case, I suggest, Your Honor. You'd be well within your grounds to issue a restraining order so he no longer can abuse her emotionally, physically, and otherwise. And I would also point out, Your Honor, that he has used the children since this order, and I suggest in violation of the order. He's refusing to see the children, even though there's a provision for visitation. So the children are coming to mother, particularly the older ones, said they'd like to see dad, and the dad's saying that you are preventing him from seeing the kids, which is essentially using a third party to cause her stress and duress. When there is an order, I even emailed my sister and said, let's set up visitation, that can occur. And I was told that he's not going to see his children so long as there's a restraining order, and that's in an email. So I suggest, Your Honor, respectfully, under these circumstances, I've met my burden of proof that an order should issue, that she should be protected and be free from abuse and threats of physical violence. Thank you.
Very much.
Yes, Your Honor. As I'm sure Your Honor is aware, there's a huge difference between a 209A restraining order and what may be sufficient for a vacate order. There are certain facts that I think Your Honor picked up on, but I think I need to reiterate. My client has been sober since March, I don't remember, you told me 10th or 12th, thank you, the 12th of 2010, 5.5 years. He has not had a drop to drink since that time. He has not had any drugs, illegal drugs of any kind since that time. She has made allegations in the affidavit. In her affidavit, she says the past 3 years. It's 5.5 years. So, first of all, anything that my brother has talked about, which are 7 years old, 7 years ago, they've had 2 children since then, and my client's been sober.
Right, but there are also, quite frankly, some rather alarming allegations of what happened recently. That's what I'm more focused on.
And let me address that. As my client said, on Tuesday evening, he happened to be walking past her cell phone, and it went off, and there was a blurb there about a plan for her to go out with another man to go out drinking. He did confront her. He was upset about it. That was the extent of it. They went out to dinner. They have pictures of the family at dinner. He went out shopping with one of the children afterwards. And I point out a couple things. First, my client is a water treatment operator. He has top security clearance down on the Cape because he runs what used to be the Naval Air Force Station and is now a joint station down on the Cape. So he's got, a responsible job. He has a 17-year-old daughter that he has custody of as a result of this restraining order. Not only was he dislocated, but the 17-year-old, who was a senior in high school taking AP classes, has also been dislocated. Her allegations that he was harassing her and disgusting her. When you read her affidavit, she says he was yelling at her on Tuesday night, makes no mention of Wednesday, Thursday, makes no mention of sleeping with cell phones under her pillow on Thursday. She makes that mention on Sunday. On Friday, he took the children down to the Cape for the 3 days, down to his grandmother's house. All was well, there were no problems. He returned on Monday evening, and at that point they had another discussion, and she asked him to leave. And what did he do? Did he break things? Did he yell, scream? He left. He packed up the 7-year-old, and he and the 7-year-old, at her request, left the house. He didn't cause any scenes. There's nothing in here that he escalated or threatened or did anything else like that. As to the gun, he says it's a total unmitigated fabrication. They have a couple of BB guns in the house, 2 of which they bought as a present for their sons that are down the basement. One that was left home in the house when they first bought the house, it was in the basement, and one which her father had given to him a couple of years ago. Other than that, he does not have a federal ID card. He does not carry. He's never owned a gun. He has no other guns ever, and it is a total, complete fabrication. Furthermore, he left on September 7th, voluntarily.
And counsel, how then is you just represented a couple of minutes ago that he and his 16-year-old daughter have been quote-unquote displaced by this restraining order. Actually, no, they haven't. If I'm to believe you, if your client and his daughter left voluntarily, this order didn't displace them.
That's actually accurate, Your Honor, and she's 17, by the way, but she's
17.
senior in high school. Mother asked him to leave on Monday evening, and he left and took his daughter, who lived in the house with her siblings for 4 years, but he left in order to not cause any problems in order to quiet down. He received numerous text messages. His phone is outside because he can't bring it in, but otherwise we can present it to you, from Mother that entire week. He left Monday night. He heard from her on Tuesday several times, all about, are you taking the kids for the weekend? I have plans for the weekend. Are you taking the kids down to the Cape for the weekend? He wrote back and said, right now, I don't have any place to live. I don't have any money. I don't know what's happening. Things are crazy. I don't know what my plans are going to be for the weekend. She wrote again on, that was on the 8th. On the 9th again, she wrote, he responded with one line and said, are you planning on getting divorced? Is this going to be a divorce? And she responded, I'm not sure. I'm not sure what I want to do. Please stop texting me. So he did. On the 10th, he received 4 phone calls from his 12-year-old saying, Mom has asked me to call you. She wants to know, are you coming to pick us up this afternoon? This was after the restraining order had been entered. So there was no contact other than text messages between these parties between the 7th and the 10th. So what compelled her on the 10th? This is not the case where they were together and things were escalating day after day after day after day. They had a disagreement on Tuesday. He went away for 3 days on the weekend. He returned home on Monday night. She asked him to leave. He did. What this really is an issue about custody of these children. And that's what this is coming down to. My client is highly involved. Mrs. works overnight as a nurse. He is there. He is the one who has been there with the children. She worked full-time up until a few years ago. But what is my client's request this morning and the discussion this morning is about he wants to be able to have his children. Our proposal was that they alternate in the house for the next couple of weeks until he can establish some place to live. He's trying to find some place nearby so he can live and have these children be able to have shared custody between the parents, between the parties. That's what is compelling and driving this. There was no, even if you read her affidavit, at best case scenario, there's no indication that he ever threatened to kill her, threatened to harm her. Even if worst case, if you take it for true, that he was saying horrible, inappropriate things in front of the children, which my client denies. He said it never rose to that level. He said we did have an argument, we did have a discussion, and he said, how would you feel if I got a text message from a woman asking about what we're going to do next week and are we going to go out? He said that, what's good for the goose is good for the gander. But he said it never rose to that level, but she doesn't even allege that he threatened her with imminent bodily harm or physical harm or threatened to do anything to her or the children. And in fact, her repeated text messages all week long about when he was coming to get the kids and spend time with the kids indicates no fear, no concern. And it was not until the 10th, 3 days later, that she came before this court and decided at that point she was in imminent fear of physical harm. She hadn't laid eyes on him since the 7th. He had left at her request. And her only concern was he going to take the children and let her have the weekend off? And when he said he wasn't sure, then we come forward and get a restraining order. My client would seek to have this vacated, Your Honor. He knows that they cannot live together any longer. What I have proposed, as I said, is a nesting situation. Her father lives a few doors down. They could alternate being in the house with the children. That would give his daughter some stability right now. And I am looking for a very short period of time, because my client's hope is within a month or 6 weeks, he will have some place to live nearby so that they can continue to have shared physical custody of these children, as they have had for many, many, many years. But many things in her affidavit are clearly untrue. The dates are wrong. The years are wrong. The alleged threats and alleged, even best case scenario this morning, violence and stuff all took place 7 years ago, allegedly, when my client was drinking. He admits it. He's been sober since that time. So what I ask that this be dismissed and that counsel and I work out a custody arrangement, because that's really what this is about. It's about a parenting arrangement and trying to get a leg up on preventing my client from having shared physical custody of his children.
Brief rebuttal, Your Honor. My sister says that my client's affidavit doesn't talk about things that happened Wednesday, Thursday night. In the middle of the paragraph, she states, the situation escalated out of control during the week, hours of yelling and screaming. That covers her during that week period that she says he was out of control. I'd also point out regarding the threats to kill her in the past, one was about 4 years ago, one was 7 years ago, so we're absolutely clear about that. So when your husband threatens to kill you, when he's intoxicated to the point of passing out in his car, that stays in your mind. When he now threatens to have a gun in the house, and he also threatens suicide, something I didn't mention on my first presentation, that's in her affidavit. On Monday, when he came home from the Cape, and this was a planned opportunity for him to be with the children, so the children were saying to her, we're going with Dad this weekend, right? So she texted him to say, are you taking the children? So she could tell them whether they're going with him or not. So it wasn't a matter of her pleading with him to take the children to give her free time. This was a scheduled thing. So he's threatened suicide, he's acting mentally unstable, he says he has a gun in the house, and he's threatened to kill her in the past. If this isn't a restraining order, Your Honor, any reasonable person would be in fear of their physical safety. She's a mild-mannered, weak woman who doesn't stand up to her husband. She's a nurse. She doesn't...
But counsel, by your definition you just gave me, your mild-mannered, meek client asked him to leave, and he did. Right.
I'm glad he did, and because it was escalating out of control, and she said, well, you've got to stop this, please leave, and he did. But I'd suggest respectfully, that doesn't mean what he did up until that point makes him a good guy or even credible.
But that's if I believe that that's what actually happened.
Right. And, you know, if my sister says nothing in my client's affidavit is true, or most of it's not true, if she were to create an affidavit to get a restraining order, she could come up with untruths that would certainly seal the deal on a restraining order. She's explained the history of what's happened here, of his tirade over a week long, not letting her sleep, screaming and yelling at her with prior death threats in their relationship, and the guy who says he's got an illegal gun in the home and threatening to commit suicide. And I suggest respectfully, any woman would be in fear of their physical safety under that circumstance.
If I could ask the parties in council to please stand. There's some concerns about what's alleged to be going on here. I'm going to continue the order of the date of March 16th at 9 a.m. here in Brockton, but only the following provisions will remain in place. All paragraphs are stricken with the exception of 1, not to abuse the plaintiff, 3, leave and stay away from the residence, and 4, remain away from the workplace. Sorry, 4A, and 12, the firearm surrender. So again, 1, 3, 4A, and 12 remain in place. All other provisions are vacated.
Thank you, Your Honor.